Good morning, everyone. Firstly, I would like to thank you for inviting me for this excellent event, for the yesterday dinner, and all of us for beautiful atmosphere that all of you create here. In the first part of my lecture, I will describe the legal basis for the hearing of the child, and in the second part, describe the standard that was last introduced in the Polish system. So, as regards the rights of the child to be heard, it is reflected both in the provision of international law, including European law, and the international law and the national law, and also in the Polish constitution. It is specified in Article 72, according to which child has the right to be heard in the course of determining his or her rights, and his or her opinion is to be taken into account as far as it possible. The most important international act in which a child is granted, this right child is granted, is Article 12 of the Convention of the Rights of the Child. And at European level, the right of the child is to express his or her view in general matter is in Article 24 of the Charter of Fundamental Rights, and more detailed is in Article 21 of EU Regulation 2019/1111 on jurisdiction, recognition and enforcement of judgment in matrimonial matters, parental responsibility and international child abduction, called Brussels II-ter, which is applicable in trans-border cases. The EU regulation and also the Convention on the Rights of the Child leaves up to the national law and national procedure to decide who conducts the hearing of the child and how it is conducted. And what is important also, that according to regulation, the sanction for the failure to hear of a child in cross-border proceeding is a possibility of refusing to recognize a decision of a court of another member state, but with two exceptions. The first one is that the proceedings concern only the child's property, and provided that the provision of such an opportunity was not required due to the subject matter of the proceeding, or where the substantial grounds which took into account in particular the urgency of the case. And now the Polish system. In Polish law, hearing of the child is an informal conversation with the child, which is aimed at guaranteeing the child the rights to freely express his view and expectation in matters that concerns him. Determining and taking into account the child's opinion is the basis for making decision in accordance with the best child interest. A case in which the child should be heard may concern in particular parental authority, contact with the child, divorce or separation of the parents, placing the child in a foster family or a care and education facility, decision or termination of adoption, other matters in area of the child's welfare. Hearing of the child should be aimed at getting to know the child's opinion and not obtaining evidence in the case. Listening to a child is not a proof. It should be also emphasized that the hearing of the child occurs regardless of whether the child is a participant in the proceedings or not. And from the other side, the providing the child with the opportunity to be heard in the proceedings concerning him or her does not automatically mean that he or she is granted the status of participants in the proceedings. It is not a right to decide for oneself, but the right to participate in the decision-making process. And the basis issue related to hearing of the child before the family court are regulated in the Code of Civil Procedure, and now also in the regulation of Ministry of Justice. The standard for hearing of the child has been specified through changes in law that have entered into force from 50 of February 2024. The purpose of this amendment was to increase the subjectivity of a child in the proceedings. And now I will present the most important changes in the law. According to the new provision, a child may be heard in family matters only once in the course of the entire proceedings. An exception to this rule is their situation in which the need to repeat an action is reported by the child, or it is necessary for the minor's well-being. Family judges are required to receive specialized training to facilitate their contact with minors as they prepare to hear and assess their developmental level, as well as to help recognize signs of domestic violence. According to the amendment regulation, in a situation where the court resigned from hearing, it is obliged to draw up a report. In this report, we must indicate the reason, and the reason shall be indicated at least for the end of the proceedings. And such regulation makes the hearing of the child's real rule not only depend on the decision or competence of the judges. The hearing takes place in the closed session in especially adapted rooms called blue rooms. This is to ensure the confidentiality of the hearing. In certain situations, it may take place also outside the court. In this regard, the court might cooperate with the non-governmental organization dealing with the protection of the children's rights. It should also be heard, the child should also be heard without the presence of the parents and guardians. Apart from the judge, only an expert psychologist can be in the room. The presence of a psychologist is justified if, due to the child's health, mental development, or age, it is necessary to provide psychological assistance during the hearing, or it is necessary to assist the judges in recognizing the child's need during the hearing. A judge hearing a child talks to him without official attire, official uniform. The meeting cannot be recorded. The way of communication with a child should be adapted to his age and maturity. And it should be borne in mind that the hearing is not an interrogation, but it is informal conversation. And it should also be conducted in the language that the child understands. The judge should adjust the course of the meeting to the child's capabilities, take care of the interlocutor's comfort, both mental, physical, and give the child a break if it's necessary. The judge should avoid direct questions concerning the resolution of the case. The child should not be burdened with information about any impact on the conversation on the court's decision. And the child should know who is talking to, who he is talking to. He has the right to ask questions. She should also know the reason for the meeting is and what he can expect during it. Hearing of a child is not intended to obtain any information by the parties, and for that reason, the court does not present the parties the course of the hearing, but only its conclusion. And a judge prepares a special note after the hearing, and this note not contain details about the child's question and answers. It is of the very general nature, which is intended to protect the child from possible negative consequences from the person involved in the case. And that's all about the standard, and I hope that these changes allow the child to be better heard in the court proceeding, avoid the stress, minimize the stress resulted from the contact with the public body, and allow the judges for the better assessment of the best interest of the child. Thank you very much for the attention.